Alrighty. I think we are live. I might be the only one here, but that's okay. I don't mind celebrating by myself on this one. As we know, the Supreme Court of Virginia has struck down the gerrymandered map. The lobster map is dead. And I hope some of you will join me because I really want to hear what other parts of Virginia are saying. Hello, everybody. Some great news for Virginia today. Bad news for Democrats. It's always good news for regular patriotic Americans in Virginia. We won today. I am going to hopefully Ken Cuccinelli, who, if you have watched, I know it's so great. And this is my first ever doing a live, so bear with me. My purple lights are probably not gonna last because they have a very short life. But hopefully we'll make it through. But I'm hoping to go over a little bit about what happened, see what Twitter is saying, and hopefully bring you Ken Cuccinelli is doing a press conference at supposed to start at 11:30, so that we can hear. I did an interview with him. Woo, geez, it seems like forever ago, but it was probably about a week, maybe 9 or 10 days ago, where he really broke down what he thought the Supreme Court of Virginia was going to do. And he said it could even go 7-0, but it went 4-3, which I believe is right on ideological lines. 4 Republican appointed, voted on Supreme Court justices in Virginia, as opposed to 3 Democrats. So I can't wait to hear what Ken says because he has got such amazing insight. Let me go to Twitter because honestly, it's happened so quickly that I don't even really know what's going on. So I like my Virginia people to tell me what's happening. So I am going to go over to my X page and share that with you and see what my Virginia peeps are saying. Holy cow, holy cow. Oh my gosh. In a 4-3, Scott Presser, who we all know spent a decent amount of time in the run up before the April 21st referendum going around Virginia. And I would just want to say, before I forget to say this, rural Virginia, because I'm here in Loudoun County, I am in the belly of the beast. I'm disgusted by what my neighbors have been doing. I am so thrilled for the other parts of Virginia. Like, I'm almost in tears over this. I'm so happy for you because what was happening was egregious. The power grab and the disenfranchisement of a huge part of Virginia. I was enraged, and I literally walk around my neighborhood going, "Is it this person that I can't trust? Is it this person that doesn't like me because of my views? Is it this person?" It's not a great way to live, but I'm so happy for the rest of you guys. So just a little bit like, holy cow, oh my gosh, this is a political earthquake. I love that. I love that. Looks as if Jay Jones was singled out by SCOVA. $80 million. Spanberger's reputation burnt up. Virginia Democrats infighting and still no budget. Oh, it's my screen share. Hold on. It's the screen share. Hold, please. Can you can't see the screen? Can you see my Twitter stream? It might be crud. Oh, this stinks. I wanted to share some Twitter stuff, but it's my first time doing a live and trying to share the screen. You can't see anything? I'm back, but I can't scroll through. So if I do this and try and scroll through my screen for you, you can't see that? Ah, harumph. I wanted to read you some tweets, but and I want to share the Ken Cuccinelli thing. Let me think about how we're going to do this. 'Cause I really it's a Zoom, so if you don't have the Zoom link, do you see it? Can you see the Twitter? Yeah, sorry. I'm a Gen Xer. I'm an old lady. I don't know how this technology works. You're seeing it with issues? Okay. Thank you guys for giving me the feedback, 'cause literally don't know what the heck I'm doing. I just wanted to until we can, share the Ken Cuccinelli Zoom, because it's a Zoom thing, and I guess if you don't have the link, you're not gonna be able to see it. I don't know. I suspect there might be I mean, this is like I don't know if I wanna say global news, but this is a huge story, so I suspect and Ken, as we all know, has been going around. He's been making the rounds on all kinds of news shows, even came on my little show. Um, and so I think he's probably in great demand because he really called this. I think a lot of people assumed that the Supreme Court of Virginia, which is voted on by the General Assembly, was going to basically just do the bidding, but he was really confident. He had said 7-0 and it came out at 4-3. He was really confident in this, which made me sleep better at night these last few weeks. Thank you, salty Gen Xers. I love you. And I love you all in the rural part. So if this doesn't work, we'll just call it a day and I'll try and grab clips of Ken. But I really was hoping to specifically share that, which starts at 11:30. Oh, thank you. But okay, so if we can see some of the Twitter stuff, Ken did hit this one I wanted to see a little bit about. I love if Jay Jones is getting yeah, I don't know. We'll have to come back to that. Anytime Jay Jones is getting hit, I am a happy camper. Let's see. Yeah. I don't know if y'all follow Brandon Jarvis over on Twitter. He's basically a mouthpiece for Virginia Democrats, so I'm sure he's not very happy today. I keep checking back to make sure you can see it. It's working. Close out and reopen YouTube. So if that might work, because especially oh, I'm sorry. I didn't know if there are ads in there. Sorry, sorry, sorry. But I especially want you to see Ken. Today the Supreme Court of Virginia defended the Constitution and the rule of law. I mean, I am so excited for this. The court made clear that lawmakers broke the Constitution by advancing the amendment. So I'm hoping that one of the things that Ken addresses, and maybe if you guys have a little bit of information on this, so to get this, I don't think that the Virginia Democrats are going to stop trying to gerrymander the map, especially while they have control of the General Assembly and the governor's mansion. But it's this intervening election that is the problem. They were trying to argue that last fall's election was the intervening election. It was not, as the Supreme Court of Virginia ruled today. So they have to have an intervening election, which I take to mean this year's midterms will be that intervening election. And then next year, their next legislative session, they're going to bring this right back in front and get it passed. Spanberger will put it on the calendar. This is what I'm assuming. Thank you, rural Virginia. I'm so happy for you guys. I really am. I am despondent having lived in Northern Virginia for a really long time. I'm despondent over the fact of what it's come and what it's trying to do to the rest of the state. So I apologize wholeheartedly. But if anybody knows, like I'm thinking that the midterms are the intervening election. And so that in their next legislative session in beginning of 2027, they're going to try and jam this through again. And of course, not just this, but all these taxes that Abigail Spanberger likes to pretend she's not going to pass, the things like taxes on gyms, dog walkers, mattress recycling, Uber rides, like the whole list that you've heard of that they haven't technically passed because they're holding their fire until after the midterm. So I'm expecting this also to go into that next legislative session because this midterm will be that intervening election that they failed the rule they failed to follow. Let's see what let me check in on. Ken has not started yet, so that's good. I love watching all the celebrations. It won't go into effect. Has struck down the redistricting. I can't read enough about it. Happy Dems spend $100 million on a legally flawed referendum ploy that ultimately got smoked by the court day to all who celebrate. And I'm celebrating. How are you guys going to celebrate? I am definitely going to happy hour today. We were celebrating something else. And on top of this is great. And who is the big loser this week? Louise Lucas. Lulu. What do we wanna call her now? She was the 10 effing 1 lady, the foul-mouthed little weed shop owner that has Abigail Spanberger under her thumb, and she, of course, had her offices raided the other day, her office in Portsmouth, her weed shop, nobody I know, it is party, 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 party night, and I don't know, I mean, I'm trying to think of an appropriate way to honor Louise Lucas and her awful, terrible, horrible, no good week, and nobody deserves it more than Louise Lucas. So, what are you guys gonna do to party? I'm thinking well, I think they did, like, a toast, like, when, after Abigail Spanberger was inaugurated, I think Louise Lucas did some sort of foul-mouthed toast to 10 effing 1, so, I don't know, champagne? Is that out of that's a little fancy. Um Yeah, I'm not celebrating yet. That's Keith in the comments. I'll celebrate when she's in jail and we all vote R in the intervening election. It is, I say we take a day, maybe even the entire weekend to party, but then on Monday, I think we really have to rethink about what's gonna happen because they're not gonna let it go. Because now you see what happened in Tennessee yesterday. You see what's happening in these red states who are like, okay, Virginia, hold my beer. Like, if this is what you're going to do, if you're going to go power mad, watch what we can do. Florida's done it. So Democrats aren't going to let this go. Power is everything to them. Power is the only thing to them. Power over you is the only thing that matters to them. So it's not going away. So, but I do think we do get to party. I do think we get to celebrate it because I don't know about you guys. Oh, yeah, Bobby Scott. Bobby Scott, not a great week for him either. Um, I just kind of assume that courts aren't gonna go my way. It just doesn't seem like in the age of Donald Trump that the courts have been very fair about any of this. So, I think we have to celebrate that. Yeah, Bobby Scott, it's the triumvirate, it's the troika of Spanberger, Bobby Scott, and Louise Lucas. They cook this nonsense up and they inflict it on the rest of us. And again, my neighbors vote for it, but they doubled the governor's security detail this morning. The court ruled that the Constitution of Virginia is not a suggestion. I know, I love it. Lucas's toast going down. I would love to see some cuffed and stuffed. I know that they're looking into Louise Lucas, but she's bad, and, honestly, I was kinda late to hearing about the decision by Supreme Court because I was working on a video for you guys about something a really bad voting law that is taking effect on July 1st. I haven't recorded it yet. Maybe I'll try and get that up for you over the weekend because, it's not good. It's not good. It is a bad law that is going to allow, Democrats to steal a lot of votes starting July 1st. Not that they're not already, but it basically kinda almost gives them permission to steal votes from a vulnerable part of our population. No, we can't rest, Keith. I agree with you. We 100% can't rest, but we can celebrate and do some, who what better time to do some strategic thinking than, knocking back a drink or 2 with your friends and coming up with a plan. Now, I think the big winner here, now if you disagree, let me know, is Jason Miyares because I he really took the lead on this. Let me quickly check the Zoom because I'm gonna stop sharing my tweet for now. And then we'll just wait for Ken's thing to start. Um, I think Jason Miyares is a huge winner. I mean, Ken Cuccinelli is also, but I'm not sure he wants to run anymore. I think this sets Jason Miyares up for a governor's run in 2029 against I don't know who the front runner would be for the Democrats, but he took the lead. He crisscrossed the state um, against this referendum. So I don't know. I think he's the guy. I think he's the guy moving forward. And I think he probably has a bit of a ground game that has developed as he has gone across the state telling them that, what was gonna happen if this referendum passed. Of course, that's the lobster map, the 10 to 1 one that's going down. So for now, that map's not happening. It's going to go forward into the midterm elections with the 6-5 split, 6 Democrats, 5 Republicans, and we keep that bipartisan redistricting commission that we voted on in 2020, the one that they were trying to do away with this new amendment. So everything is status quo for now, but of course, with the Democrats in charge, it ain't gonna stay that way. I'm just trying to catch up with you guys. Yeah, Jason was a great AG. And the story that I'm working on for you on this new voting law, is he's part of that, what was he was looking into before. Unfortunately, he was not reelected, and we got Jay Jones foisted upon us. A big another big loser, which you gotta drink to this, you've gotta drink to this, is Barack Obama. Barack Obama, he comes in here, he gloats, he smugs, he's got his nose up in the air. It's a great day when Barack Obama loses, and this is a big loss for him. I look forward. Hopefully, Ken can tell us a little bit more about who he might think the big losers are in this, and you let me know who you think the big losers are. It's obviously Louise Lucas. It's 100% Spanberger. She put that video out. They made her the face of it. Remember that? Like that, and then they kind of cut it because they were like, "Oh God, she's really unpopular." When her popularity rating was, not as good as it should be, having just taken office. Um, she's a huge loser. That's a lot of political capital that she just killed. I'm just checking. I don't want to miss a second of Ken. Doesn't look. Let me just check that they haven't emailed anything. No, no, nothing yet. Yeah, there was a bipartisan reason the commission was formed, and we voted for that, and I don't have their exact numbers, but I think it was like 65% of Virginians that voted in November of 2020 on the referendum voted for this. We did not want state legislators to be the ones to draw the lines. And of course, I'm gonna do Keith, I'm gonna do on, whether we can recall Spanberger. It's not a lot of great news there, but, I'm gonna do a video on that. I'm still researching what all the details are, so that's forthcoming. But unfortunately, I think we're probably stuck with her unless there's, a DOJ investigation, and who knows? They're investigating a heck of a lot of stuff. I've noticed since, Pam Bondi left, dare I say that things have kicked up a notch in the, investigation. All right, this is when it's supposed to start, the Ken briefing. It's a press briefing, so, the way they handled it last time is the press just, because it's a Zoom call, they just submitted their questions via chat, like a chat question thing. So if you have any questions you want me to throw in there for Ken, I think it's gonna be a great he's gonna give us all the he might get a little in the weeds. Ken's a legal guy, he might get a little in the weeds about it, but yeah, it's up to the General Assembly to remove the governor, unless there's some other bad thing, which I'm sure there is, but I don't know if we'll find out about it just yet. But I wanted in that video, I also want to talk about because I'm also really invested in Fairfax County. I grew up there. I live in Loudoun now, but I grew up in Fairfax County and I just don't recognize it anymore. On Steve Descano, like he can be recalled. There's a lot of people. We might not be able to get rid of Spanberger, but we can send Louise Lucas to jail. Don Scott can't go to jail because Joe Biden pardoned him. But there's a lot of things we can do that could really hamstring her. And of course, the best thing we could do is to vote more Republicans into the General Assembly. So, we can't do that until 2027. But yeah, yeah, the lieutenant governor's not great either. Like, I literally have so many videos I want to make for you all because I don't know if you've ever taken a dive into the lieutenant governor. Yeah, Ken's not on yet. Um, she's not a really nice person either, is she? She's pretty bad. I don't know if she's the front runner, like to take on Jason Miyares, but that would be something else. Now, I would have thought in this last election that we could predict that someone like Jay Jones wouldn't be elected, but I was proven wrong on that one. Yeah, I don't know about the auto pen issue, but Don Scott was one of those January 19th, 2025, the day before Trump was sworn in for his second. Don Scott was one of those people because he, of course, is an ex-con. He spent time in jail. He was a drug dealer. So now he's supposed to be this great story of a reformed person. I think that's what Biden or the auto pen said about him. Was he's reformed and this is America at its best. We can always do better. Yeah, our lieutenant governor, Gazala Hashmi, I don't even know how to say her name. She's not great. Come on, Ken. I need to hear from you. He has not logged in yet. And one of the interesting things that I think he's going to cover today, and I talked to him about it on the interview I did with him like last week, is the fact that the Supreme Court didn't act before The Supreme Court of Virginia, let's be clear, didn't act before the April 21st referendum. They were considering this, I think, back in February, March, that they could have stopped the referendum from going forward because of these lawsuits that most of them that come out of Tazewell. And cheers for you guys down there. They didn't take any action. They said, we're going to let the referendum go forward, and then we'll consider after all the votes are counted. And of course, the extra votes from Fairfax County had to be counted too. And then I took that to mean there's no way they're going to undo the will of the people by this vote. There's no way they're going to nullify the vote, but they just did. So I really hope, Ken said, don't read too much in the fact that they let the referendum go forward, that was not an indication that they would not take this seriously, that they would uphold the vote, the referendum, and let the gerrymandered map go forward. So where is he? I bet you he's like all over Fox. I bet he's got so many media. Oh, here he goes. Hold on. Let me share. Oh, where is he? Hold, please.
And the way I will conduct this is I'm going to do
I got double Zoom
summary walkthrough.
Give me a second.
And then I will do a longer form version. You are welcome to send Melody Clark questions as we go. I will attempt to answer them as I go.
Can you hear him?
And then at the end of the longer form explanation, then I'll open it up to live Q&A. So first, a summary of what has happened. The Virginia General Assembly, as you all know, in 2025 passed for the first time a proposed constitutional amendment, a state constitutional amendment. All constitutional issues here are related to Virginia's state constitution. And they did that in 2025 on Halloween. On Halloween, the Democrat-controlled Virginia General Assembly passed its gerrymandering amendment for the first time. Virginia's state constitution has a requirement in Article 12, Section 1, that there be an intervening election between the first passage of a proposed amendment and the second passage of a proposed amendment. And in Virginia, we have our state elections in odd years. You will all recall that now Governor Spanberger was elected last November, as was the entire House of Delegates of Virginia. That was a Virginia state election. And the Democrat General Assembly wanted the court to consider that election the intervening election required under Article 12, Section 1. The problem is, the last time the Democrats had full control in Virginia, they gave us a 45-day election that began on September 19th of 2025. So by the time the General Assembly passed the gerrymandering amendment for the first time, Virginia's election had been going on for 6 weeks, and over 1.3 million Virginians had already voted. Now, we have had over 60 constitutional amendments proposed since the 1971 rewrite of Virginia's Constitution. Never before, in over 60 different instances, has the Virginia General Assembly passed a proposed amendment while Virginians were voting. Never before. This was unprecedented. And the Democrats' position, carried by the Attorney General Jay Jones, was that the election, for purposes of that intervening election requirement, was just Election Day. And so the fact that Halloween was before Election Day, they argued was adequate to fulfill the requirement, the strict requirement of Virginia's Constitution. The majority today rejected that argument by a vote of 4-3. That 4-3 vote broke down on partisan lines. I'm sorry to say that the 4 justices who voted to reject the referendum as unconstitutional were all appointed by Republican General Assemblies, and the 3 in dissent were all appointed by Democrat General Assemblies. I'll come back to that point later, but this was a 4-3 decision rejecting the referendum. That means that Virginia's current 6-5 map remains in place and is the official map of Virginia for now and the foreseeable future, in the absence of some other attempt by the General Assembly to properly amend the Constitution. And to be specific about that constitutional amendment, the gerrymander amendment was intended to replace Virginia's 5-year-old bipartisan redistricting commission, which had passed by a 2-to-1 margin in just 2020. That was what they were attempting to undo. There is a second case that enjoined the certification of the referendum. That case is now moot and will never be decided by the Virginia Supreme Court because the referendum has been thrown out. There's no need to address the other constitutional and statutory violations by the Democrat General Assembly. Additionally, there's a third case addressing the gerrymandering maps themselves, and that, of course, is also now moot because the referendum was thrown out, so the General Assembly could not draw new maps. And so Virginia's congressional maps for 2026 remain the same as they were in 2024 and 2022. Going through the opinion, that's the summary version. I'm looking at my notes here. I would note for the lawyers listening that there was absolutely no mention in the opinion of the statute that was alleged to have been violated. Virginia Code Section 30-13, which requires circuit court clerks to put a notice on the courthouse door 90 days before any election of then operative proposed state constitutional amendments, like the gerrymandering amendment. So under that statute, the clerks would have been required to post the language of the amendment on the courthouse door in June. Well, the fact that the Supreme Court ignored that and decided a constitutional issue based on the theory of constitutional avoidance, by which courts try not to reach constitutional issues if there's another way to decide the case, indicates that that statute will never be useful to a challenger in getting a referendum thrown out if it is violated and clerks of court don't post notice. So that is the statutory challenge that was part of this case. The other constitutional challenge that was part of this case was related to the General Assembly's use of the special session, and there were two problems with it. First, it was called in 2024, May of 2024, to deal with budget issues. So first is the agenda. It dealt with the budget and those things in the budget resolution, and the resolution said that the agenda could only be changed by unanimous consent. Well, they changed it by majority vote to add the constitutional amendment. So the agenda change in violation of their own resolution was issue one. Issue two, these are state constitutional issues, was the fact that that special session allegedly carried over through and passed and out of the 2025 general session of the General Assembly. And the argument of the challengers was, the Republicans in this case, was that the general session of the General Assembly ends any special session because general sessions are unlimited, anything can be proposed. But the court, in footnote 6 in particular, said we are not going to reach that question because we have decided the referendum was unconstitutional under Article 12, Section 1, and so there's no need to reach the questions related to the General Assembly's special session. So to recap, there were three legal challenges: a statutory challenge that the clerks didn't post notice of the amendment prior to Virginia's 2025 election. That challenge was ignored by the court, literally wasn't even commented on by the majority, indicating that the court will not throw out a referendum based on that statute. The intervening election requirement of Virginia's Constitution was violated. That was the determination of the court that affirmed the finding below of the lower court and thus threw out the referendum. And then the third challenge, the constitutional challenge on the special session issues, was raised but explicitly not addressed because the case was resolved on the other constitutional basis. I would note that the majority opinion went to some length in laying out legal authority that would question whether that special session would have been viable, even in the absence of the court's ruling on the Article 12, Section 1 provision. Okay, that is the summary. Melody, if you want to lob me questions, any questions that have come in, I'd rather take them in writing than live. I would also note that I've tweeted a summary. It's pinned to my Twitter page at this point along those lines. And yeah, go ahead, Melody.
Sorry. If you click on the Q&A at the bottom of your Zoom screen, you can see the questions. There
okay.
you go.
More Q&A. Got it. All right. From Joe Thomas, Jay Jones has issued a vague and rambling statement regarding defending the rule of law. This was his position all along. And while not explicitly saying they're going to challenge the ruling, they made it clear they were considering challenging the ruling to defend. So this is a really strange statement from the Attorney General of Virginia. Note, these are all Virginia state constitutional issues. The final authority in America on the Virginia state constitution is the Virginia Supreme Court. This case is over. There is no challenge for the Attorney General to make at this point. If a new map is to be concocted, the General Assembly will have to come back into session, basically go back to the drawing board, pass another proposed amendment, and then, or I'd have to go look at the wording of the amendment, but perhaps they could rely on the passage in January of 2026 as their first passage, but the next time they could address it for second passage wouldn't be until 2028. So it is theoretically possible that they could run an exercise like this again and clean it up, if you will, in which case we would probably have a referendum in June of 2028, which would be very difficult. They'd probably have to set primaries literally in September of 2028, unprecedented in Virginia history, in theory, to change the 2028 maps, assuming they won on all issues and didn't once again violate some constitutional provision. Attorney General Jay Jones, since the referendum, has been taking the very unlawyer-like position that the yes side won, of course, by that margin was about 3%. And he's defending the voters. Presumably he means the side that won the vote, but he's not saying anything about defending Virginia's Constitution or laws, which were violated rather brazenly by the Democrat General Assembly. And I would note that in oral argument, the very first question from Justice Wes Russell to the lawyer for the Commonwealth, Richard Hawkins, who was hired from out of state to come argue a Virginia constitutional issue, which is odd. But the first question to him was, does the outcome of the referendum last week matter at all in the legal consideration of the issues we have before us? And Jay Jones' own lawyer said, no, Your Honor, it doesn't matter at all. Thus yanking the rug out from under the public narrative of his own boss. But he was legally correct. The vote, as noted in the majority opinion, is irrelevant to the consideration of the opinion. The opinion did address why they did not rule on the referendum prior to the vote. As I have said, for those of you who have followed my commentary on this, over 100 years of precedent, ironically, dating back to a case with the name of Scott, just like Don Scott, our current speaker, the Virginia courts don't address the constitutionality or legality of referenda until after the vote. The vote is part of the legislative process. It is analogous to a governor signing or vetoing a bill out of the General Assembly. You would no more sue on, we have an assault weapons ban that will probably become law in Virginia, but Governor Spanberger hasn't acted on it yet, and no court would hear a challenge to it until she acts on the bill, presumably allowing it to become law or signing it into law. So the efforts by the Attorney General, the public narrative they've carried on has suggested they didn't have faith in their own case. From Orrin Oppenheim, do Democrats or the Commonwealth have any recourse or way to appeal the ruling? No, they do not. As I mentioned, the Virginia Supreme Court is the final authority on Virginia constitutional questions. This is the end, folks. You will have the same map in 2026 for the congressional elections that existed in 2024. That is now unchangeable and immutable. That does not mean maps couldn't be changed by 2028, but they will not be changed by 2026. Further question, could the governor order the SBE to ignore the ruling? What would the ramifications be? In theory, I suppose, but then Congress probably wouldn't accept the people seated, and that means all 11. That would be an incredible act of defiance of a court order. And Spanberger, when she was a candidate, she railed against redistricting. Now, of course, she flip-flopped immediately on this and cooperated with this radical gerrymander effort. But I have a feeling that she is going to declare the court to have addressed the subject and say that it is done and over, and it's time to move on. I can't imagine her directing that. And then, frankly, if you are one of those individuals, are you going to accept the governor's invitation to break the law? And I think you'll find people are unwilling to do that, because then they subject themselves to personal liability under civil rights laws. So no, this is the end, folks. This case is over. These maps are with us for the duration of 2026, period, in Virginia. Not seeing other Q&A questions here, Melody. I am going to, oh, wait, I've got a chat here too.
No, I was just giving everybody your byline.
All right, so go ahead.
I think that you got all of those questions currently, yes.
Okay, folks are welcome to address those. Melody, if you could somehow treat them as answered so they go off my screen, that would be great. Now, for those who are a little more geekily inclined, it's my intention to walk through the court's opinion. Okay, I'll interject. Michael Pope, the partisan breakdown of the justices. So Virginia is one of two states where the General Assembly picks the judges and justices of its courts. 4 of the currently sitting justices were selected by entirely Republican General Assemblies. Those 4, in order of their remaining tenure, are Arthur Kelsey, who authored the opinion in this case, and his term, we have 12-year terms for Supreme Court justices, ends at the end of January of 2027. That means that this General Assembly will select his successor or reappoint him. I think that it is safe to say that this General Assembly will not reappoint Arthur
Huss,
Kelsey.
Huss. Oops,
Excuse me.
sorry.
The next up would be Steve McCullough. Up in 2028, there will be an intervening election for both the House of Delegates and the State Senate in 2027, prior to his either reappointment or replacement by the General Assembly. And then comes Teresa Chafin from Southwest Virginia. She's a number of years out. And the Republican justice with the longest tenure remaining is Wes Russell, who is not up for another 8 years until 2034. And I will remind folks that it was Justices Wes Russell and Steve McCullough who were virtually the sole questioners for the duration of the oral argument to both sides. The exception to that is the newest Justice Fulton, selected by this General Assembly just in January, who did interject one question in what looked like an effort to help the Democrat lawyer or the Democrat side by challenging Tom McCarthy, the lawyer who argued on behalf of the Republicans. I did not argue this case. I should make that point. Some people think that because I'm doing commentary, I was on the legal team. I was not. Tom McCarthy was challenged by Justice Fulton with respect to one of the voters. One of the plaintiffs is the Democrat voter who voted early and was a strong supporter of the bipartisan redistricting effort and was very upset at this gerrymander effort. But she had voted early with no knowledge that on Halloween, the General Assembly would advance an amendment to get rid of the bipartisan redistricting commission, at least for a number of years, and that her own delegate, Delegate Willett, proposed that constitutional amendment, and she would have voted against him. And Justice Fulton challenged the procedural posture of that voter's assertions, and in an attempt that sounded to me like to try to help the Democrats, and of course he voted with the dissent, so that seems like a logical conclusion on my part. But it face planted, as Tom McCarthy pointed out, that the complaint was a verified complaint, which means all the plaintiffs swore to their statements as if it was a perjury statement. So they swore to the truth of those statements, and the Democrat General Assembly nor its lawyers never challenged those statements. So they are in the record as facts. And the Justice Fulton's effort to attempt to help the Democrat position backfired, and it strengthened Tom McCarthy's position on behalf of his Republican clients. And as I noted, he had Democrat clients as well. They were the only three justices who spoke: Russell, McCullough, and Fulton. None of the others spoke. Justice Fulton was just added to the bench. Justice Powell, Cleo Powell, my greatest disappointment here. I've always viewed her as a judge's judge. This was an extremely political dissent. The reaching and stretching intellectually and legally, and really flipping legislative interpretation on its head, literally prioritizing new statutes as an interpretive tool for what is an election versus 150-year-old constitutional provisions, was very disappointing. I had viewed her, as I said, as a judge's judge. I really didn't view her as having much history of partisan decision-making, but this was a very partisan dissent on her part, and she authored the dissent. And the third, Justice Thomas Mann, also Democrat selectee. Further question, from Megan Moore, will today's decision by the Supreme Court of Virginia have implications on the other referenda across the country? It will have no legal implications, but each of those states will respond, as they will, on a political and a policy basis. We saw Florida already act very much in response to the extreme nature of the Virginia gerrymander, and they are proceeding. Now they are at the point of receiving and dealing with state constitutional challenges, and I don't pretend to know the Florida Constitution to tell you how that will go. But again, these are not federal legal challenges even in Florida. Florida's response to Virginia is still a state constitutional challenge for, in that case, the Democrats are the challengers. And we'll see how that plays out in Florida. But surely the brazen, almost gangster legislating fashion in which the Democrat General Assembly brazenly bowled over the Virginia constitutional restrictions, and they were so public about it. I mean, Louise Lucas infamously all over the country selling her 10 F and 1 t-shirts. Maybe she'll sell 6 F and 5 t-shirts now, or 4 F and 3 t-shirts for her bail fund. But that the brazenness and the nastiness of it surely sort of twisted the knife in other folks in other parts of the country. But Megan, in answer to your question, on a legal basis, the Virginia outcome in this case has no bearing legally on any other state, well, one, gerrymander decisions. Those are political and policy decisions. And two, because it was based on our Constitution, this is really, as a matter of precedent, only applies to Virginia. Now, many states require an intervening election between two passages by a General Assembly of a proposed state constitutional amendment. That is not an uncommon requirement. It is a very common requirement. And you may see this case cited as persuasive authority in other states on the same question, if, as, and when that arises. But that question will not arise with respect to the sort of redistricting scramble that is going on right now, or being considered basically only in red states. I guess Illinois is thinking about it, but overall in red states, in part because of the Calais decision out of Louisiana as well. So the timing of the two is unusual. But that is not a Virginia legal question. All right, so if I may turn to the opinion itself, this is going to get a little more long form for folks. And I'm primarily going to focus on the majority opinion because they won. I will note some of the arguments made by the dissent, but my focus here will be on the majority opinion. It was 4-3, as previously noted, for the latecomers. The 4-3 vote on the Virginia Supreme Court divided along partisan lines, and with the 4 Republican selected justices voting to reject the referendum as violating Article 12, Section 1 of Virginia's Constitution, and the 3 Democrat or justices chosen by Democrat General Assemblies dissenting from that opinion. And this is final. There is no appeal from here. There is no way to change Virginia's maps under Virginia law for 2026. So this sets the maps. Really, it keeps the old maps in place for Virginia for 2026, and we will see what the General Assembly does going forward. But they can't change maps again until the earliest 2028, and that's if they figure out a way to obey the Constitution and start doing things in an orderly fashion. So the majority opinion walks through a good bit, not surprisingly, of the history of Virginia's Constitution. We are the oldest colony and state and constitution in the country. And we have an awful lot of history to actually go through. They do touch on the fact that this is a partisan gerrymander. They don't comment on that. They simply reflect on that, particularly in the context of the vote by the people of Virginia 5.5 years ago in 2020, to create a bipartisan redistricting commission. They reference that right off the top of the opinion. And note that the people there expressed by a rather overwhelming margin their desire to take partisanship out of redistricting, and that they do touch on the bare margin of the referendum, winning by 3.x points, yes over no. And then they proceed to quote the oral argument I cited earlier with respect to the fact that the outcome, yes beating no, regardless of the margin, is irrelevant to their consideration of the legal questions, constitutional questions before them. They note that what they call a disputed 2024 special session was used on Halloween of 2025. They don't say Halloween, they say October 31st, 2025. I say Halloween because it's creepier. Was when the Virginia General Assembly passed this proposed amendment, undoing the bipartisan redistricting amendment in first passage. And they note they did that on a party line vote, and that the proposed amendment would temporarily suspend the bipartisan redistricting provision of Virginia's Constitution. The temporary nature of this was that it would be in application through the 2030 elections. So what the Democrat General Assembly was trying to do was change the maps. Of course, for 2026, the whole theory of their case was get Trump. But those maps would have been changed for 26, 28, and 2030 elections, at which time, under this proposal, the Bipartisan Redistricting Commission would have kicked back in and drawn the maps for the 2032 and beyond congressional districts. Many of you know that the wording of the Virginia ballot measure was, I'll just say, extraordinary. And Melody, if you could grab that and put it in our chat, I'll read it to folks. But it spoke of restoring fairness on a temporary basis. All of those ballot language questions were in the second case that the Supreme Court of Virginia will never get to because they've already thrown the referendum out. The same trial court found the provisions of the language put forward by the Virginia General Assembly to violate our plain English rule, that it was so misleading. It said you would be temporarily voting to restore fairness. That's what a yes vote was cast as on the ballot. That's the language you would read there. And it was pretty extraordinary language, but that was not addressed by the Supreme Court. It was addressed by the Virginia trial court. And I would note that we have other constitutional amendments, including the most extreme abortion amendment in the whole country. And it's a transgender abortion amendment coming that'll basically permit anything. And they have used similarly misleading and biased language. And that is already being challenged very much in parallel to the challenge that you saw to the gerrymandering language on the ballot measure. So we're going to have another version of this come up in Virginia on a different amendment. So that's something that for Virginians here will be an issue.
Ken, I have one other question. What exactly would the legislature have to do to go forward with redistricting at this point? That's another question we have. Start the process completely over.
It is completely over for 2026. Basically, to undo, first of all, to do any redistricting at all, the Virginia General Assembly has to get the Constitution of Virginia amended. That's what they were trying to do here, because there's a bipartisan redistricting amendment that restricts things to only every 10 years. You can't do mid-decade redistricting in Virginia based on our state constitution. and they were trying to undo that and retake control to the General Assembly for the next 3 election cycles. And that was rejected today by the Virginia Supreme Court. If they want to try again, they will undoubtedly repass a new amendment to undo the Bipartisan Redistricting Commission, presumably in their 2027 general session. And then they will pass it again, assuming Democrats retain control of the General Assembly in the 2027 elections, when both the Senate, which I believe is 21-19 Democrat, it's not a huge majority, and the House, which is a much bigger majority, are both up. But let's assume they control that. Then they could pass it again in 2028. I assume they will be more cautious about obeying the Constitution this time around, which would mean that the timing of the referendum in 2028 wouldn't be in April. It would be in June if they're careful about it. And that's if Spanberger is willing to cooperate again and again make herself a liar and a hypocrite on gerrymandering, which she talked one way rather vociferously and vigorously for many years, until she was in a position to do something about it, having won the governorship. They have to get her to go along. But in theory, they could make it work to change the Virginia maps for 2028. But it will not help them to accomplish that with an extreme map, because they're also going to have to contend with federal legal challenges. Now, I mentioned the ballot language, and I want to read it for folks. And in fact, for you media folks, I will put it in the chat as well. But I want everybody to be able to hear it. Should the Constitution of Virginia be amended to allow the General Assembly to temporarily adopt new congressional districts to restore fairness in the upcoming elections, while ensuring Virginia's standard redistricting process resumes for all future redistricting after the 2030 census? That was the ballot question. So, temporarily adopt new congressional districts to restore fairness. There's no question that this was very misleading language to a lot of voters. Was it enough voters, 1.7% of the voters who voted, to actually change the outcome? I don't know. But it was an extremely misleadingly worded question. And the trial court, the same trial court who was affirmed today by the Virginia Supreme Court, found this language to violate our plain English statute and for ballot language. So, we're going to see another one of those challenges. Other states other than Virginia regularly have litigation over ballot language. We have not historically had that. But this General Assembly seems quite determined to word things in a squirrely way that they believe gives them an advantage with the voting. And it gives them some advantage, but it also makes them legally vulnerable to having the referendum rejected. So that's an interesting trade-off on their part. Back to the majority opinion. As I noted, they did cover what the current map looks like, and they spoke about the expected outcome of 10-1, and then said that is not a consideration for us with respect to the legal issues. I noted to you all, pointed you to footnote 6. That is where it's an extensive footnote where the majority lays out the 2 legal challenges to the use of the special session by the Democrat General Assembly. They walk through them. They provide a lot of legal authority that would question the legitimacy of the use of the special session particularly because it overlapped a regular session. They spent more authority on that subject, including citing some big guns. Thomas Jefferson's Manual of Parliamentary Practice, a big deal in Virginia. Mason's Manual of Legislative Procedure. Again, you know, we're Virginia. We've got James Madison cited in the first pages of the majority opinion. We've got Jefferson, Mason, people who are deeply involved in the drafting of Virginia's original Constitution in the case of George Mason, and the United States original Constitution in the part of James Madison, with major influence, of course, from Thomas Jefferson, who wrote the Declaration of Independence. So we've got quite a bit of history for the court to reflect on, and they spent a good bit of time reflecting on that history. And they implied that this 10-1 map was very unfair, given the outcome with 51% of Virginians and so forth. But again, they walk through all of that, I think, just to be comprehensive and to lay out the full context, but they explicitly reject any consideration of those factors in their consideration. They do note that early voting was March 6th of 2026, and they call that the submission to the voters. The submission was accompanied by the ballot asking questions, and they walk through the ballot question. It is very significant that they use the word submission with respect to the early voting on March 6th. Again, they didn't reach the 2026 questions, but the constitutional violation in 2026 was that there was not a 90-day gap between the second passage of the proposed amendment by the General Assembly on January 16th and submission to the voters 90 days later, which the Constitution requires. Because the General Assembly wanted to treat the entire election as election day, they treated the 90 days as running against April 21st, the day, election day, the last day that the referendum could be voted on. I read the Virginia Supreme Court writing this particular way. The submission was accompanied to be a warning to the General Assembly that submission will be judged by the 90 days to the first day of early voting, not to election day. And so if they come back and try this in 2028, I would not expect to see the voting day on the referendum to be in April. I would expect them to give themselves the full 90 days before early voting, or they may shorten the early voting period. And nobody needs 45 days of early voting anyway. They may shorten the early voting period, say to 15 days, and hold the referendums maybe in May. And that would position them as a matter of math to avoid that constitutional challenge. I see the Virginia Supreme Court making clear that this court, now it'll be a little different when the next case is decided, but this court would find the first day of early voting to be the point at which the question is submitted to the voters. And that would have failed on that constitutional challenge. That is right in this opinion, right up front on page 5. And but again, they talk about it in terms of the history of how we got here. And then the voting on April 21st, they note that they recite the number of yes votes, 1.6 million, number of no votes, 1.95 million, with a 3.38%. They're very specific about the margin, and that the difference was a swinging of 1.69% of total votes. Very specific. But in a constitutional republic, it is emphatically the province and duty of the judicial department to say what the law is. So they move into the opinion quoting Marbury versus Madison. And of course, John Marshall was a Virginian too. For you non-Virginians, you should note all these Virginians involved in this history. And they cite one of their predecessors all the way back to 1782, Judge Wythe, who was on the Virginia Supreme Court in 1782. And he stated, and they quote him entirely, if the whole legislature, an event to be deprecated, that means it would be very unfortunate, should attempt to overlap the bounds prescribed to them by the people, he means in the Constitution, I, in administering the public justice of the country, will meet the united powers at my seat in this tribunal, and pointing to the Constitution, will say to them, here is the limit of your authority, and hither shall you go, but no further. And that is the position the majority places itself in, ruling against the Democrat General Assembly in this case. And they go on, they cite a great deal of Virginia tradition and judicial history, including the Scott v. James case. Same name as our current speaker, Don Scott. Scott v. James from 1912 is the case that set the precedent for the Supreme Court not touching a referenda until the voters vote. Again, as I said earlier, that people voting in a referendum is analogous to a governor signing or vetoing a bill. It is part of the legislative process. That is why the Virginia Supreme Court did not act in February. And mind you, Virginia Attorney General Jay Jones, on behalf of the Democrat General Assembly, asked them not to act. And the court recites, you asked us to hold off based on legal precedent. You were right, we held off. But now you can't ask us, because there's been a vote that squeaked by where one side prevailed over the other, to not address the constitutionality and the statutory consistency of the referendum. Otherwise, there would be no review at all. And they cite that, they walk through that rather clearly. Including, they quote the Commonwealth, which is the Democrat side in this politically, extensively in their requests for a stay. And the stay, of course, was granted. The referendum was held, and then the court addressed the case. And they said, having successfully insisted that we postpone judicial review, it might be tempting to rely on the final vote. If this supposition were true, then judicial review of allegedly unconstitutional procedures used to adopt a constitutional amendment would not exist in the Commonwealth of Virginia. And so they reject that argument, which is the argument that Attorney General Jay Jones has been using in the media since the vote. He hasn't relied on law. He hasn't relied on the Virginia Constitution. He has simply argued the outcome happened. It's my job to defend the outcome. He couches that as defending voters instead of defending the Constitution, which I would point out is what he swore an oath to defend. On the issues before us in this case, we hold that the ultimate vote margin plays no role in the analytics of our judicial review of the constitutionality of the pre-election constitutional amendment process. And then they go on to actually apply their analysis to find that Article 12, Section 1 mandates a detailed process governing the adoption of constitutional amendments, that they may seem laborious, but they are important, and they are strictly, and they are to be strictly complied with. That is the standing law of Virginia. And as I go through, I'll interrupt to address some questions. This illegal referendum has been a huge waste of time and money. That's true for Virginia localities. Are they reimbursed by the state? There is no. In Virginia, the state had a line item for about $5 million for the state's portion of the cost of running the election, but local governments bear the cost locally. So this was a huge monetary imposition on all of the local governments of Virginia, pursued brazenly unconstitutionally. And there's no provision for the state government to refund those monies to the local governments. So they are out of luck and out of the money. Back to the analysis. The General Assembly can propose amendments, but it cannot adopt them. this indirect process where the General Assembly proposes amendments to the people, and the people have two opportunities to weigh in. One, indirectly, by voting on who is in the General Assembly in the intervening election, and once directly, voting on any proposed amendment. And it is the indirect opportunity for the voters that the majority says was not offered, was not complied with. Because 1.3 million people had already voted, in turn, because the election had already begun, that election could not serve as the intervening election required under the Virginia state constitution, what the court calls our organic law. And this is not new. This is a 150-year-old requirement that comes into play because, as cast against this 150 years of history, the dissent looks to the statute where the Democrats established early voting, and the phrasing they use there along the lines of voting early in the election. And the dissent wants to treat that phrasing as pointing to the fact that the election is just election day. The majority walks through cases all over the country, which I am very familiar with. The questions like this have been dealt with by federal courts in the 4th, 5th, 6th, 9th, and 11th circuits, and they have all come out the same way, consistent with how the majority ruled in the Virginia Supreme Court today. There is no case finding that a multi-day election counts for the election purposes as only being election day. The Supreme Court in Foster v. Love similarly says that federal elections must be consummated by election day, not all executed on that day, but consummated. That was a case that addressed Louisiana having its jungle primary in early October, and if you got over 50% of the vote, you were elected. Well, that violated federal law for federal elections that's been in place for almost 200 years, that being requiring that all states complete their elections on the same day. Pardon me. So there are no cases supporting the dissent on that, and they are essentially trying to take recent statutory language to trump 150-year-old constitutional language in the Virginia Constitution. So the majority in the case today walks through a lot of the discussion of these provisions of the Constitution in the 1971 amendment process. In 1971, Virginia's Constitution was revisited and in some respects amended, not with respect to this part of the Constitution. And there's extensive discussion, including about this provision, all of it supporting the majority's conclusion today. Then they go on after recounting that history. I mean, folks, all of the history here, the history of the Commonwealth, the history of the Constitution, the history of the amendments to Virginia's Constitution, both distant that set this process up in the 1870s and recently in the 1970s, the most recent rewrite, all support the majority's conclusion, and the dissent doesn't cite to any of it because they can't. They can't rely on the history or legal tradition of Virginia because of how brazenly the Democrat Virginia General Assembly trampled that history, tradition, law, and precedent in attempting to jam this gerrymander through for 2026. Well encapsulated in Louise Lucas's 10F and 1 t-shirt. Shows real respect for the legal process about the amount that you would expect from Louise, but also the amount that was shown by this General Assembly. And the Supreme Court rejected that trampling of Virginia's constitutional requirements. After they walk through that and find that the use of the word election, election day, general election, there are many different uses of that in the Constitution and statutes, and they read them all consistently, and they point out that if the dissent's version were accepted, all uses of election and election day, all of them, would refer only to the one day, which wouldn't make any sense, even in the early voting statutes that the dissent itself cites to. So they are really attempting to rewrite history and the law to achieve the outcome the Democrat General Assembly that they have clearly bowed down and groveled to here wanted. And it's a very sad day. This should have been a 7-0 ruling. I'm sorry to see this extreme example of partisanship on the part of what I'll call the Democrat appointees. That's never been a distinction that mattered so much before in Virginia. And I'm afraid that we are heading that direction, and that is a direction this General Assembly frankly wants. We'll probably see, the next appointment replacing Arthur Kelsey will probably be a state equivalent of a Justice Jackson, who just rules on an outcome basis without regard to the law, as the dissent tried to do here unsuccessfully. There's a little bit of teasing by the majority in here, noting the 4-day period in between the first passage on Halloween of the proposed amendment and the election day also included a weekend. And by the way, in that weekend, if memory serves, we don't even have early voting then. So early voting was actually over. And the only thing left to do was receive mail-in ballots and for in-person voting on the election day itself on November 3rd, I believe, in 2025. In the half century, just since the 1971 Constitution, now mind you, this is the same process before then, but the majority in the Virginia Supreme Court only counted back to there. The General Assembly has approved 63 amendments for placement on the ballot, and voters have ratified 54 of them. In none of those instances did the General Assembly behave the way it did in this attempted gerrymander. They never before tried to jam amendments through while people were voting. They always respected the process before, literally in the last 63 attempts on the part of the General Assembly. And the court then goes on to lament how the General Assembly and the Commonwealth and the Democrats dump on the 1.3 million Virginians who voted early before Halloween, and that they don't matter, that their constitutional right to an indirect say in this constitutional amendment process being brushed aside was brazen, abusive, and unconstitutional. But that's what they were doing. That's what they were doing. And then they go on to note, to counter the arguments, as I noted, on election being one day versus the whole process. They cite cases, not binding, but from all over the country. As I noted, 4th, 5th, 6th, 9th, 11th circuits and the U.S. Supreme Court have all found rulings in various types of cases, at least consistent with the Virginia Supreme Court's ruling today, and there are none consistent with the dissent's position. And that cites all the way back to the beginning of Virginia. So I won't belabor this too much. I would note that there was also some parsing of the English language. We are a plain language state, much more so than a legislative history state. For those of you who follow federal disputes, you'll hear a lot more legislative history. It weighs more heavily at the federal level than it weighs at the Virginia level. I have pinned to my Twitter page a summary of this account, if you will, of the outcome for today. But this is a great day for for the people of Virginia. This is a great day for actual fairness, not the kind of squirrely ballot language fairness the Virginia Democrats tried to jam down our throat here with the help of supposedly anti-gerrymandering Governor Spanberger, who flip-flopped on this. And the finger pointing is going to be something to behold. I will get my popcorn and watch the Democrats shoot at each other over that. You're going to hear from Scott Surville, the majority leader. Oh, we checked with all our lawyers. I would note Scott Surville is a lawyer, but not a very good one. And nor apparently were the lawyers they checked with. I challenged him on Twitter to name those lawyers. He won't do it because first of all, none of those lawyers want to be named. But I'm sure it was Mark Elias and his firm and, Hakeem Jeffries lawyers and so forth. They weren't Virginia lawyers. And my last comment as a former attorney general is some disappointment with Attorney General Jones in importing a lawyer from California to argue a Virginia state constitutional case. Unlike the federal Constitution, which a lot of us deal with as lawyers, various parts at various times, very few people in the legal profession anymore, after the New Deal era, really operate and deal with their state constitutions. I would note that on the Virginia Supreme Court are two of literally the greatest experts in Virginia on the Virginia Constitution. If I could name on one hand lawyers who are the premier experts on the Virginia state constitution, Justices Steve McCullough and Wes Russell would be among them. Both of them litigated the state constitution. Steve McCullough, great for years before they went on the bench. I would also name Bill Hurd, former Solicitor General of Virginia, and Pat McSweeney, who was there when they wrote the 1971 Constitution. And I've still got a finger remaining. And so two of those four are on the Supreme Court. They led the questioning. It isn't just because they had questions about this. They literally have more experience litigating the Virginia Constitution than almost any lawyers in Virginia. And the institution that holds the most experience litigating the Virginia Constitution is the Attorney General's Office of Virginia. And yet our current Attorney General, Jay Jones, did not look to one of his own lawyers in the office to argue and lead this effort. And that is mystifying to me. I don't understand that. I can only conclude he doesn't trust either their abilities or he's paranoid that they won't agree with him or argue sincerely. They're professionals in that office. I think that was a bad judgment on his part. I think it was a mistake, though I don't think it would have changed the outcome. I think within the legal community, that will be found to have been a peculiar decision on the part of our current Attorney General. I hope he doesn't make that mistake again in the future and he respects the people in that office. I certainly did when I got there. And on no issue does that office have a greater advantage over the rest of the world than on matters relating to the Virginia state constitution. Sorry, Joe Thomas, I'm going to skip those questions. We can do that on your radio show sometime in the future, but I'm going to conclude. We've been on just over an hour. I was trying to keep this under an hour. I hope that's been very thorough for you all. I would say, look, read the opinion. It is an outstanding piece of legal and historical scholarship. You will learn a lot reading the opinion. It is outstanding. It is an A++ opinion. I am very impressed with Justice Kelsey in his walkthrough here, his calm demeanor related through his written word. And it is also a badge of courage in a state where the General Assembly reappoints or doesn't reappoint justices when he is the next one up to be the one to write the opinion telling the General Assembly, look, you did this the wrong way, and I'm obligated as a justice of the Virginia Supreme Court to call it that way, and I hereby do. And he did, as did Steve McCullough, Teresa Chafin, and Wes Russell. They're all to be commended for their courage. This is not an ordinary case. It took courage on their part, and they all demonstrated it. Thank you all very much. God bless Virginia, and God bless America. And I'm sure there'll be more discussion of this as time goes on, and you are welcome to follow us at our Election Transparency Initiative webpage, electiontransparency.org. We also have Twitter handle ETI_now, and I will continue to comment on it. Some of it humorous, I hope. I have a low threshold for humor. It'll be funny to me, I promise. At Ken Cuccinelli on Twitter. Please follow me there, and you'll keep up with all the developments that roll out of this, including other people's commentary, which I have every intention of commenting on. You all have a great day. God bless.
Well, that was a pretty good analysis there from Ken. So thank you guys so much for being here. It was my very first live stream, and I'll do better next time. I think I messed up. There might be ads running, which I don't want to have on a live stream for sure. And I think hopefully you can hear me. My voice sounds very strange to myself. And we'll make the comments, the chat go a little faster next time. But you guys are awesome. I love your comments. I'm good. This will be up later as a video. So if you need to go back and see anything that Ken said, it'll all be up there. I'm planning on going to pour one out this evening for Ken. Okay, let me back up. Pouring it out for Barack Obama, Louise Lucas, Hakeem Jeffries. There's a whole Abigail Spanberger. I'm going to be toasting the wonderful justices that got this right, but I'm going to be pouring one out for those who got it so very wrong. So thank you guys. Really appreciate you being here. I will be back very soon with that video that I was talking about in the chat on a new election law that is gruesome and horrible, as you can imagine. But go enjoy the rest of your day. Enjoy this, because this is a fabulous day for Virginia. So congratulations to everybody for voting the right way, and for the Supreme Court of Virginia for getting it right. So have a great Friday afternoon. I'll see you guys next time. Bye.